So, interestingly enough, when Dr. Gold spoke about, who's here and on what capacity, in some ways I wear two hats, so to speak, because for 20 years I was in Batei Midrash, and I taught there and I studied there, and I'm on a personal level asked questions of Jewish law, especially with regard to actually reproductive technologies. And as a scholar of Jewish law, I now sit in the Ministry of Justice in the Jewish Law Department. And this kind of laws that Avi Shalom spoke about just now are the kind of legislation we work on from the perspective of Jewish law. So it is interesting to me, and I do ask myself, what is the value of the perspective of Jewish law as to what's going on in the Israeli sphere? I will start with the Israeli law, because I think that other than the specific nurses that underwent this special training, I think that this innovation in Israeli law is very important. In Israeli law, before 2016, we had the law of agency that stated that when you have an agency, it ends either with the repeal of the agency, the death of the agent or the principal, or loss of capacity. That means that the Western concept that we find in most Western countries of durable power of attorney was not an option in Israel. Interestingly enough, Justice Barak, not in his capacity as a judge, but as a scholar, was of the opinion that this was dispositive, and that actually both sides could stipulate that an agency would continue after loss of capacity if that was specifically stated. But that was not necessarily the majority opinion. And in fact, the courts in general held that a power of attorney ceases when the principal is no longer able to understand the nature of the agency, even if he was not formally declared not to have legal capacity. Meaning, even if we just knew and we could prove it, that would nullify the use of the power of attorney. And accordingly, in the law of capacity and guardianship, there was only the possibility of guardianship. If a person wanted to plan for his future or her future demise, they were in the throes of some sort of degenerative disease, they could not do so. They would know that in a few years, someone would force on them a guardianship, or a person, unfortunately, everybody, the ones that are fortunate, grow old. And the kind of guardianship that would be possible would be a forced guardianship. Excuse me, I just want to take off my watch because then I can see it. There was a tremendous reform that came into play. It was passed not in 2006, but in 2016. That's a typo. But it actually came into effect in 2017. And this, if you're going to take a picture of any slide, this is the one. Notwithstanding the law of agency that we just heard about, anyone who did a durable power of attorney, this will not end just because the principal ceases to be competent. This is the basic principle. In this case, if you did this specific durable power of attorney, it has tremendous details and clauses, and it takes, and actually lawyers that want to use the durable power of attorney have to go through an entire 2-day seminar in order to be qualified, and in fact, there are a lot of details. Also, the durable power of attorney that when it's entered into force does not in and of itself deny legal competence. You can have a person legally competent, and their power of attorney, the durable power of attorney, will also come into play at the same time. Okay, so it doesn't also imply that the person, that the principal is not competent. So we have this innovation now in the law of the durable power of attorney. We have this innovation of a pre-designation of a legal guardian. A person does not have to wait and wonder what the courts are going to do in terms of appointing a guardian over themselves. The third, of course, incredible innovation is that in addition to appointing that proxy, a person can give advance directives either for the person holding the durable power of attorney or just in general. And those advance directives are also binding. The fourth innovation, as you see up here, which is very important, is what they call the letter of an expression of will, which means that if a parent or another person has guardianship and they are worried that the person over which they have guardianship, right, something will happen to them, and the child will not have a guardian, they are now legally able to appoint a guardian. Whereas before, they could give their preference. Let's say a person was preparing a will. They could give their preferences to who the guardian would be, but now they can write an actual legal directive who would take over for a guardianship that they hold, which is very important to many, many parents. And also coming into effect in 2018 was the idea of a decision-making supporter, because the entire thrust of the law was to give people as much personal autonomy as possible in making their own decisions. So this is something that, even if a person has a guardian, they can also have a decision-making supporter so that they can be part of the decision-making process, or they could have a decision-making supporter without having a guardian. Sometimes a person has the durable power of attorney and also needs a guardian because it's not full enough, it's not broad enough to cover all of the areas in which they need help. Now, the most important thing for this conference, and that's the last point here, is that the durable power of attorney now replaces the power of attorney that was in place under the patient's rights law. I think that not everybody in the health profession is aware of that, and it makes very stringent stipulations as to how to do that. It does not override advanced directives or a proxy caregiver in the dying patient's law. That's left on its own. And we spoke about before the fact that, as Rabbi Dr. Halperin said, many of these areas combined aspects of Jewish law or Jewish values and general ethical values when they were instituted, and had a very specific balance put in place in the law. That law was deemed too delicate to touch, and it was not overridden by this law. Okay, so what do we see in terms of incapacity and agency in Jewish law? The Mishna GIttin says if a man was seized with a kordiakus, which there's different, but we're just going to say it's a temporary incapacity. And he said, write a get for my wife. Writing a get, as you know, is the Jewish bill of divorce. He did not say anything, meaning this appointment that he gave while he himself did not have legal competence is not valid. But if he said, write a get for my wife, and then he was seized with kordiakus, and then he retracted it saying, do not write a get for my wife, i.e., when he was incompetent, he wanted to revoke the power of attorney, so to speak, that he gave. His latter words have no effect. Well, that's really nice. But what happens in between? The entire question we're trying to ask here is, can a power of attorney continue to have effect when the person has become incompetent? Not when he gives the instruction, but what happens if he's actually incompetent now? Can I use the appointment that he gave at the outset, let's say in this case, for the agent to give a get while he's incompetent? When would we want to use this? Especially if you think about Jewish law and the laws of Gittin. A woman, chas v'chalila, you heard about Supreme Court case, whose husband is now unconscious, or who's in a vegetative state. What if he gave such a thing to begin with? Could now the appointee use it now while the husband is not competent? So that's very interesting. Just pointing out, I'm going to go straight to the Gemara that says there's a dispute on this. Rabbi Shimon ben Lakish said the get may be written immediately. And Rabbi Yochanan said it's not to be written till he comes to himself again. So what's the reason of Reish Lakish? Because it's stated his last words are of no effect. And Rabbi Yochanan answers, yes, his last words are of no effect means only that when he recovers, the scribe doesn't have to ask him again. That's what his last words are of no effect. But the get itself, in the interim period, you can't write it until he comes round to his general competence. So in what do they differ? Reish Lakish puts the man on par with one who is asleep, and Rabbi Yochanan puts him on par with a madman. A madman at that point in time, right? What is the presumption? That a madman cannot what? Cannot give a get. And the other presumption is that what? If he can't, then his agent can't at the same time, because a person has to be competent to do something. Otherwise, his agent cannot do the same thing for him at that time. So they both really, on a basic level, accept the principle, both of them, that while the person does not have legal competence, even if it's temporary, we cannot use this agency to give the get to the wife. So now we want to know, so in that case, what if someone did? What if someone used this agency anyway and tried to use it to get? Will have any effect whatsoever? And here we have another dispute, and this is of the rabbinic sages of the medieval period, where Maimonides says, no, but the get is not completely invalid. Its invalidity is only on the level, as you spoke before, of a drabanan level, of a lesser level, but it has a certain amount of validity. But Baal HaTurim, Rabbeinu Yaakov ben Asher, said that, no, it is eino klum. It is nothing. So it seems at least that if we were to use this as our paradigm for what Jewish law would say about a durable power of attorney, what would our conclusion be? No durable power of attorney. However, this is not the law of agency in every area. Maimonides and the Tur spoke only about Gittin. Maybe there's a difference. So the Ketzot HaChosh and Rabbi Aryeh Leib HaKohen Heller said that according to two things that are very, very important for our discussion. According to Maimonides, the get has legal force, right? Even though the sages made a rabbinic actment that it be considered invalid on the level of D'Rabbanan. But what's the reason for that? It's local to the laws of divorce. It's so that people don't confuse this with the ability to appoint an agent while he's not competent. But it's only to minimize that confusion. It's not a basic invalidity. Well, in that case, would we confuse it in other areas of law? No, we wouldn't. We don't have the same requirement in other areas of law. We wouldn't have the same problem in other areas of law. So certainly according to Maimonides' paradigm, in other areas of law, we would be able to use a durable power of attorney. But what about Rabbeinu Yaakov ben Asher Baal HaTurim? What then? It seems, and this is the majority opinion accepted, that durable power of attorney has no validity under Jewish law. So there's three different lines of reasoning that we can use. One says all agencies are not valid while the person is not competent. Durable power of attorney is not valid. The second says that divorce laws are unique, that they need will, ratzon, of the husband, and therefore the durable power of attorney in general is valid. When would it not be valid? In divorce law. It's a specific area of law. The third, which is the most interesting, which I'd like to focus on just before I conclude, is that the laws of divorce are unique, but not just unique unto themselves. They represent an area of law, right, which are of a personal nature that you cannot appoint an agent for, okay? Now, what's remarkable, if I wanted to compare the two laws, I would compare maybe these three questions. I'm going to focus on the first, the potential scope of powers of the agent. What did the law actually say? In 32 Vav Aleph, there's a limitation on the durable power of attorney that says that you can appoint an agent except with regard to those things that by way of their nature inherently must, or by law, must be done personally. Well, that seems to mesh beautifully with the third perspective in Jewish law, doesn't it? There are certain things that by nature must be done personally. Now, so I told you I work in the Ministry of Law, and so I'll give you an insider's view. I asked one of the main people who worked on this piece of legislation. I noticed that between the proposed legislation and the final law, it specifically said that you cannot appoint an agent to perform marriage or divorce on one's behalf. So why doesn't that appear in the final legislation? And she said, well, it appears. It says, except for things that of their nature are of a personal nature. But I said, wait a second, I want to press this question further. You guys did not specifically mention marriage and divorce. Well, she said, you know what? It is a very sensitive issue. We left in place the clause number 79 in the law that says anything that religious law would allow, we will not touch. And we weren't sure if in all cases religious law would disallow this type of agency. And so we want to leave it for the interpretation of the courts and not override. If there would be a rabbinic court that would allow such a thing, we didn't want to be the ones to stop it if there was this type of a great need. So I won't go into further detail, but I would say that it is very important, I think, generally in a comparative law perspective, to be familiar with the durable power of attorney in Israeli law that has all its unique, but certainly for Israeli healthcare workers, this is, I think, of extreme importance and allows for a great deal of autonomy in personal decision making. I just want to address one last thing. Is that okay for one more minute? Yeah? Okay. Rabbi Rappaport spoke about the fact that Adam Yodea Marat Nafsho, that a person knows, and that there's an idea in Jewish law for that reason, maybe, of personal autonomy, but not for the reasons we think of it in Western thinking, for different reasons, and maybe for very rational reasons, because it's a predictor of this kind of case. It's very interesting to me to ask whether under Jewish law, the notion that one appoints a proxy or a durable power of attorney for healthcare decisions, what kind of validity that would have. Because on the one hand, that person is supposed to take into account what that person would have wanted at that moment in time, if it's an end-of-life type of decision. However, it seems that the uniqueness of what that person himself says under Jewish law is at the moment that he's making that decision, and not in a prospective, forward-looking way. So that there might be a certain tension there with regard to Jewish law that I don't know if is fully settled, neither in the ethical department nor in the Jewish law department. Thank you very much.
Thank you. Thank you.